Hello, everyone. Welcome back to The Whole Truth. I, Gillard Bell, your attorney at law, your MAGA attorney at law. And today, what I want to do is go through the newly filed Bindover brief in the Tyler Robinson case. This brief was just filed by the defense. And as I've been saying from the get go, Tyler Robinson's defense lawyers are not going to be saying the same stuff that we're hearing from the likes of Candace Owens and Baron Coleman. And the reason is simple. Tyler Robinson has good defense lawyers. They know what they're doing. They know the rules of evidence. They know how to fight on their client's behalf. And so I think, and I'm not sure because I haven't read it yet, but from what I've been hearing about this Bindover brief, they're doing what they should be doing, which is arguing against some of the additional charges besides aggravated murder. I think witness tampering and the like. Arguing against the aggravating circumstances, the enhancements, the sentencing enhancement charges, and not really disputing the evidence. And the reason is simple, is because the evidence itself is hard evidence and it's overwhelming. And so Tyler Robinson's defense lawyers are good defense lawyers, and they're fighting where they can. Now, this is not to say that this is, the whole case or anything like that, but I think it will. Hi, Texas, Motherbird. Thank you. I think it will provide some insight into how the defense is planning to go ahead. And as I said, and I'm a criminal defense lawyer, what I would be doing is trying to find as much mitigating circumstances right now as possible to argue for a plea deal that spares my client his life. I think the best that can be hoped for is life without possibility of parole, but you want to fight for maybe 25 years to life. And so that's what it seems like his defense lawyers are doing. So we're going to go through it together. I have not gone through it yet, so this will be the first time. Let's get started. And let me just set it up. By the way, I have gardeners in the backyard, my dog here. So if there's distractions, I apologize. So this is defendant Tyler Robinson's preliminary hearing briefing. We have, the table of contents can sometimes be really interesting to see. So you have introduction, argument. The state has not met its burden to show probable cause by relying on hearsay in violation of Mr. Robinson's constitutional rights and separation of powers principles. Arrow. Thank you. Okay. As a matter of law, the state has not established and cannot establish probable cause to support the aggravator that the shooting knowingly created a high probability of death to another individual from the single shot from a high-powered scoped rifle from a rooftop vantage that hit the intended target. So this is talking about the aggravating circumstance, which makes it aggravated murder, capital murder, capable of receiving a death penalty as opposed to simple homicide. And the aggravating circumstance in this case that is presented is that Tyler Robinson did not just kill Charlie Kirk, but he also put other people besides himself and besides Charlie Kirk's life at risk by doing it. So it seems like that seems to be the first argument, is that because this was a single shot from a high-powered scoped rifle, notice how they're actually admitting it here, or conceding that, that hit the intended target, it did not put anyone else at risk. I don't think that's going to be that strong because that bullet could have gone through and hit other people. So I don't think so. And I'm not going to get into every single legal precedent that they bring up. I just want to hit the main, the main ideas here. Okay, so and then we have a bunch of I'm trying to think, trying to see if any of the sub paragraphs or subsections are very interesting. I think that, and we'll get to it. This is just the table of contents, but line of sight. Okay. Um, Second point, count six must be stricken. Count six, I think, is the witness tampering, if I'm not mistaken. Because evidence does not establish that Mr. Robinson's statement to Mr. Twiggs to ask for a lawyer and stay silent was intended to obstruct an investigation. Now, of all the arguments I've heard, and again, I haven't read this yet, but of everything that I've heard, count six, that one seems like it might be the most likely to win. That he will not be bound over on count six. Him telling not to speak or to ask for a lawyer and stay silent, I don't know if that's really would be witness tampering, because you're allowed to tell people their rights. And again, sorry, I do have the gardeners over. So I think that might be the actually the only thing that they might win on here. But we're just going through the table of contents. Of course, there's always something, right? So the gardeners are here. They should be leaving within a few minutes. Okay, count seven. Count seven. What was count seven? Was that the one where uh, on, discharging a firearm in the presence of a child under the age of 14? Um, so count seven must be stricken because the evidence does not establish that Mr. Robinson had knowledge that a child under the age of 14 was present and would see or hear the commission of the charge homicide. So I'm not, I guess he would have to have knowledge under the statute. It couldn't just be that strict liability, meaning that just the fact that a child under the age of 14 was present might not be enough to be guilty of that crime if you don't know, if you're unaware that a child under the age of 14. Okay, so anyways, we're getting a good glimpse into the main points being presented here. The defense is really, other than the first point about hearsay, which is that's just a very general argument, it seems like, kind of against the whole Utah statute that says reliable hearsay is allowed in preliminary hearings. So they're preserving that on appeal. Wow. A lot of authorities. This is a long Bindover brief. How many pages is this? 41 pages. So this is really long. His attorneys are putting up a really good defense. Okay. Let's see. On introduction on September 16th, state charged Tyler Robinson with capital offense of aggravated murder and other lesser offense. State had over 10 months to investigate and develop legally sufficient evidence that Mr. Robinson knowingly created a great risk of death to another other than Charlie Kirk and the defendant. So that is the aggravating circumstance. And right off the bat, that's what it seems like the defense is arguing against, that aggravating circumstance. See how the defense is operating here is not the way that Baron Coleman and Candace Owens are. They're actually fighting where it's possible to fight. The aggravating circumstance, the other lesser charges, and the sentencing enhancements. That's where there is chance of some success. Not against the evidence, because the evidence is strong. It's hard evidence. They're not going to dispute it. Okay? They're not going to bring up conspiracy theories that have no other evidence in that support them. They're not going to be allowed to argue those alternative theories. They have to have some evidence to support it. So what is the defense going to do? They're going to argue again. You always argue that the prosecution hasn't met their burden of proof, period. You always do that. But the strongest defenses that they're bringing up are against the other charges, the aggravating circumstance. So it's just Candace Owens is once again on the wrong side. What else is new? State's presentation of its evidence as to this alleged circumstance in aggravation wholly fails to carry its burden of proof. The state's failure cannot in any manner be attributed to any orders by this court limiting its proof. Okay. So it's just this paragraph is basically saying the defense is arguing. Sorry, I really hope that the gardeners leave soon. But the defense here is saying that the prosecution had every opportunity to investigate and present and do everything necessary to support the aggravating circumstance, and this is not a legally procedural question. It's just saying that it did not meet their burden of proof, which right now is just probable cause for everything, all the charges. It's just probable cause. Okay. The state is required as a matter of law to show more than a possibility that someone else may be killed by defendant's conduct, rather that there was a high probability of that result and that the defendant knew of that high probability. And the state, where the state has overwhelmingly failed to make this showing, it asks this court to expand Utah's narrow construction of the great risk of death aggravator using decades-old cases from another state jurisdiction. Binding constitutional precedent under Utah law and U.S. Constitution demonstrates. Okay, so they're really honing in on the aggravating circumstance. That, again, the aggravating circumstance in this case is that Tyler Robinson's shot of Charlie Kirk also created a great risk of death or bodily harm to others other than Charlie Kirk and other than Tyler Robinson. I don't think that they have a very strong case here because just common sense would lead you to think that there was a great risk of bodily harm to others, right? What if he missed? What if the bullet went through and ricocheted and hit somebody else? So we're gonna see. We'll see what their argument is here, but to me, it's kind of common sense that obviously, when you're taking a shot from 140 yards in a crowded area with a high-powered rifle, you are creating a risk. And the only time that this would not apply is if it's a situation where the murder is like a one-on-one, or if it's like a knife that really doesn't put anyone else at risk. So I don't think that they're going to win on this argument, just common sense wise. Okay, constitutional rights. This is about hearsay. Okay. So here it's saying that a lot of testimony, or a lot of evidence, not just testimony, sorry, a lot of evidence, the text messages, the Discord chat, came from Lance Twiggs' testimony, and Lance Twiggs' testimony was hearsay because he was not in court subject to cross examination. So they're saying that um, this is a constitutional violation. And this is just kind of a general argument. It's saying that the same constitutional principles that apply at trial, because yes, at trial, Lance Twiggs is not going to be allowed to. They're not going to be allowed to bring in Lance Twiggs' testimony via recorded statement. They're going to have to call him as a witness, and he's going to have to be subject to cross examination. Basically, what they're saying here is that that same constitutional principle should apply to preliminary hearings. So they're saying the Utah statute violates the U.S. Constitution. Hold on, everybody, because my dog is about to go nuts, possibly. Okay, so we survive. So, anyways, this is like a purely kind of a constitutional argument against the statute of Utah that lets you bring in hearsay. It has nothing to do with the specifics of this case. Now, okay, this evidence came from or became presumptively admissible through a recorded interview. A witness the court would not allow Mr. Robinson to seek to subpoena from another state to testify at the preliminary hearing. Was Lance Twiggs living in another state? Um, Honestly, if I'm a defense lawyer, I would also ask uh, to have subpoenaed Lance Twiggs to be able to cross-examine him. But it's just we're just dealing with the preliminary hearing. There's no way that he's not going to be bound over. So again, it's just saying as a matter of law, state has not established probable cause to support the aggravation that the shooting knowingly created a high probability of death to another individual. And sorry, when I said earlier that the aggravation is death or bodily harm, um, I was wrong. It's great risk of death. It's just death. So, saying again, that aggravating circumstance was not met, probable cause to support it was not met. A lot of kind of just repetition, citation to case law. I'm not going to get into all the legalese. I really want to just focus on how stupid this makes Candace Owens and her side look. That's the main focus of this video. Again, it's just providing legal definitions. It's saying that the Utah and U.S. Constitution say that you have to look at these aggravating circumstances very specifically. You can't just be general. And so saying, did the prosecution meet the burden of proof that there's an aggravation that puts somebody else at risk of death? Obviously, the defense is saying no. Now it's referring to other cases. So in this past case, um, or let me actually say, the only case in which a court upheld a conviction in reliance on this aggravating circumstance, and this happened in Supreme Court of Georgia. Sorry, maybe I should go a little bit. Okay, so it's saying the U.S. Supreme Court twice examined this aggravation of putting someone else at risk of death, only twice, and saying again that it has to be very narrowly interpreted. So in this one case, the Supreme Court upheld it, and in that case, somebody stood up in a church and fired a gun indiscriminately into the audience. On the other hand, in another case, they reversed a finding when the victim was kidnapped in the parking lot. Now it's pointing to another case where the defendant murdered two of the victims in order to avoid a witness to the first murder. So that would obviously, I mean, I'm not sure how that's just not double homicide, but I guess it's an aggravating circumstance on top of the homicides. So basically, their main argument here is that constitutional principles make it so you cannot make an aggravating circumstance for a death penalty to be so broad. Um, it has to be very narrowly specified. And they're saying that in this case, the aggravation is not there because in other cases, when it was applied, there was multiple rounds that were discharged, um, hitting other people, whether or not they died. So now it's talking about how, I mean, it's getting into really the weeds of concatenating series of events. You know, how soon after were the acts in order to be determined if they were aggravating enough or not. Here it's saying that it was not upheld where the defendant attacked a husband and wife with a shovel, killing the man. And that was not enough to say that the aggravating circumstance was met because it was separated. The husband and wife were separated. So the state produced no evidence indicating that wife was placed at grave risk of death by defendant's battery of husband, nor did it produce evidence indicating that defendant knew that his conduct towards husband placed wife at great risk. I'm gonna kind of go. This is all again arguing that the whole point here is to argue against the death penalty. Take the death penalty off. It's not aggravated murder. It's just regular murder. Nobody else was at great risk. Pointing to a lot of other cases, a lot of precedent, nothing to do with the specific evidence in this case. Not disputing any evidence in this case. Let's see where it talks about how it is here. Right now, again, it's just kind of pointing to past cases. This is like a really well-written brief with a lot of precedent cited, a lot of thought that obviously went into it. So now it's talking about this case. So preliminarily, Mr. Robinson must alert this court to a significant problem presented by the state's arguments as to the facts established at the preliminary hearing. The state makes little effort to distinguish between the evidence it presented and inferences it asked this court to make based upon that evidence. Rather, the state pursues an unconstitutional expansion of the KGRD. That's the aggravation being used here. Okay, more just legalese, kind of just talking about what's presented by the evidence versus speculation. So the state's arguments regarding the aggravator without drawing inference upon inference, as the state asked this court to do. So it says on the afternoon of September 10th, several thousand people gathered in and around an amphitheater to watch and listen to Charlie Kirk. At 12:23:28, Mr. Kirk was struck by a projectile on the left side of his neck, and the injury resulted in his death. Not an exploding microphone. The best evidence of the events are the videos. Okay. Okay. States Exhibit 12.1, 12.4 are compilations of UVU surveillance footage from that day. At 5:33, surveillance depicts the roof of the Lucy and the walkway between the Lucy and the computer science building, beginning at 12:15. At 0:16, the shooter is seen going over the railing separating the walkway. That's what Bagley called a little guardrail, probably a couple of feet high. And what Candace Owens and Jimmy Dore say you have to be Spider-Man to be able to get to. Each of the videos then jump to 12:22:12 when a figure is seen running west. Okay, going south to west. Okay. So just rehashing some of the testimony about the shooter position. Officer Bagley observed shoe print in grass. We didn't really hear much about the shoe print yet. Okay, Officer Bagley testified there's a clear line of sight. Now it's just describing what the video footage showed. It's really just restating it. Approximately 415 feet, approximately 68 feet difference in elevation. Okay, little geometry for you. Mauser Model 98 rifle was recovered the northeast in a wooded area across the street from the northeast corner of the Lucy Center where the individual ran after jumping from the roof. The rifle was 30-06 with the scope. Bolt action. In order to load it, lock it, as well as extract anything that's in the rifle, the user has to manipulate the bolt. When law enforcement manipulated the bolt, the rifle had a fired cartridge case inside and 3 unfired cartridges, all with etchings. Okay, video also, or the exhibits also contain video of an individual. The state's witnesses identified Mr. Robinson entering and exiting campus parking structures 4 times, twice before the shooting, once at the time of the shooting, and once after the shooting. A vehicle is seen matching Mr. Robinson's on campus. Okay, this is really just a rehashing of what the preliminary hearing evidence was. I'm not going to redo it because I already did amazing videos about it. I really kind of just want to address the new points here. Okay, none of the footage shows the individual identified as Mr. Robinson passing by or near individuals that are clearly minors. See, again, see the subjects of what the defense is going after, the details. They're arguing that he had no idea there was anyone under the age of 14 there. Therefore, that last charge should be dropped. The communications between Mr. Robinson and Mr. Twiggs indicate Mr. Robinson's intention to kill Charlie Kirk. There is no mention of any threat or intended harm to any other individuals. So the second theory is an everyone near. The first theory of the line of sight formulation, I don't really get what it's discussing. Line of sight theory, based upon this, so it never really describes what the line of sight theory means. Second theory is an everyone near argument, which relies upon only one of three factors identified in this prior case and ignores the two other ones. Moreover, the state asks the court to speculate about the shooter's knowledge, even assuming that one can infer a knowledge of some risk to the shooter. The state has failed to show that the actual conduct created a high probability. Oh, it's going to actually get into the line of sight. This is just the introductory paragraph. So the state broadly argues that certain individuals were in the shooter's line of fire, and then we're already almost done with this. This is what the whole thing is focusing on. The whole thing. They're focusing on saying that the aggravating circumstance is not met here. That the evidence is pretty overwhelming. They're not even disputing the evidence. They're not even, because they have no reason to. They can't just lie. Lawyers are not allowed to just lie. Now, they're allowed to say that the prosecution has not met their burden of proof, but they're not allowed to just lie and be like, oh yeah, well that evidence is fabricated, because that would be lying. And they know that the evidence wasn't fabricated. So they're good lawyers. This is what good lawyers do. They find where there are weaknesses. And this aggravating circumstance, reading through it a little bit more, I don't think it's going to win, but they're doing a pretty good job here. And maybe there'll be a little bit more to it. Maybe I don't know. They're doing a good job of arguing that maybe it doesn't reach the required aggravating fact. But again, common sense would kind of lead you to believe that, like, look, you take a shot of somebody in the middle of a crowd, you're putting other people at risk. This is not like you're going into someone's house at night and you're taking one shot at somebody in their bed by themselves. That, obviously, you cannot consider that putting anyone else at risk. So that's just common sense, but we'll see how it plays out. But the main point here is that they're arguing to save the client's life here. They're not arguing against the evidence. I'm gonna kind of, if you were looking for like a super thorough analysis, then this is probably not the video for you, because I'm just kind of doing a summary analysis here. And my whole the main reason is to make Candace and her cult and Baron Coleman look retarded. By the way, everyone, if you have not yet subscribed or liked or shared or hyped or commented, please do. I also have a video with the eclectic journalist that just came out. I haven't even seen it yet. I'm continuing past this. This whole thing is all about the aggravating circumstance. You guys can read it. Andrea Burkhart has this on her Substack. That's where I got this from. Talking about lack of accuracy relating to the scope, or absence thereof. And that's what they're hammering really hard. They're trying to save this guy's life. They're not trying to discount any of the evidence. Now we're on to, finally, we're at page 33 of 41, and we're done with the aggravating circumstance. And this one is, personally, my money is on this one actually winning. Because count 6 charges Tyler with tampering with the witness because directing his roommate to stay silent if police question him. I don't think that's witness tampering. You're allowed to stay silent. You're not saying, you're not telling, didn't say lie to them. He didn't say don't cooperate, he just said stay silent. By telling Mr. Twiggs to exercise his right under the Fifth Amendment to ask for counsel and remain silent, Mr. Robinson attempted to induce his roommate to withhold testimony or information. Yeah, I agree. Every person in this country has the right to remain silent. I think that this is the one that's going to win. They're going to have to drop this one out of the 7 charges. Mr. Robinson's advice to Mr. Twiggs was as follows. Notice, doesn't say the fabricated text messages because they weren't fabricated. You can't lie. So Mr. Robinson's advice was as follows. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you. And make sure the police follow the right procedures, proper warrants and stuff, but be polite and respectful, of course. Yeah, that's not witness tampering. Here's some more of the text messages. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here. I only hope they let you visit. I'm going to miss you too. Please be good for me. If you need anything at all, both of my parents are willing to help you. Please go to them. Leave the room alone. The feds will search it top to bottom for certain. Then work with my family to sort it out, what goes where and such. In response to Mr. Twiggs' question, what? I don't even remember this stuff. Where did they? I don't remember these text messages. In response to Mr. Twiggs' question, is there any way you don't go to prison? Mr. Robinson responded, I highly doubt it. I will update you as much as I can. If you need a place to stay, I'm sure my family would have you in my old room. You are all I worry about, love. Don't talk to any media, please. Don't take any interviews or make comments. I will always love you too. I will write to you, blah, blah, blah. If any police... Okay. Okay. There we go. I think that is the only one that will win. And if I'm right, then you'll know that I'm the best defense lawyer. Then count 7. So count 7 is discharging a firearm. I think this is a Utah thing, so I don't know it off. Exposing a child under the age of 14 to the charged homicide. So I guess committing the crime, whatever the charge is, in the presence of a minor. So this one also, though, it says there's two elements to the crime. I'm just talking about the 7th count. There has to be a child under the age of 14 present. Okay, I think the defense showed that. And Tyler Robinson had to know about it. So this one also, actually, I don't know if there was any evidence presented that Tyler Robinson knew that there were any children there. Because yeah, there was no evidence that he was aware of. What do you guys think about this one? If he had to know that there was a child under the age of 14 present, forget about your bias, your dislike of Tyler. Um, no, save smiles. It does not mean he's not pleading guilty. Um, but what do you guys think about just this count? Do you think that this one's gonna win, or do you think it should win? I don't know, because if they did not present any evidence that he knew there was a child under the age of 14, I don't think that they established probable cause on this one count. Um, what do you guys think? You guys are talking about black cherry Pepsi. Um, okay, that's I don't know. And now it's talking about the sentencing enhancement. And again, just arguing that constitutional grounds difference. So here's the big takeaway. And I bet that these are good lawyers. Um, the big takeaway is what I've been saying throughout, which is that because Tyler Robinson has good lawyers and not Baron Coleman or someone that listens to Candace Owens, they're fighting where they can. And where they can fight is the aggravating circumstance. My prediction is they're not going to win on the aggravating circumstance. They are going to win on the one count of witness tampering against Tyler Robinson. As for the last count, that one is the hardest to predict. Because I did not hear any evidence that Tyler Robinson knew there was a child under the age of 14. And if the prosecution didn't bother to bring that specific thing up, and it may be just that I didn't see that part. But if that's the case, then that one might be dropped as well. So, in summary, I think they're going to get, if I had to bet money, definitely count 6. Was it count 6? Maybe count 7. Probably, if I had to pick, I would say yes to count 7. No to the aggravating circumstance. Everything else stands. He's going to plead not guilty. And it's going to still be pled to life without possibility of parole down the line. Yeah, there were children under the age of 14, but the premeditation is not an aggravating factor, at least not the one that they are using. They're just talking about the great risk of death to others. Oh man, it's hot where I am. Great risk of death to others. Yeah, Tyler telling Lance to not to talk to police or anything, I don't think that's witness tampering. Maybe if you went a little bit further, well, he did go a little bit further, but I think that there's 2 counts of witness tampering, if I'm not mistaken. And the one count where he went further, they're not even arguing against because they told him to burn the message or delete it, delete the exchange. I think that has to do with the second count of witness tampering. and I don't think they're disputing that, but they're talking about the other count, telling him not to talk to police and stay silent. I don't think that counts as witness tampering, personally. Oh, that's a good point, Saves. That's a good point. Talk to TPUSA employees. He could have seen children, teens there. Um, that's a good point, but was that argued specifically by the prosecution at the preliminary hearing? Because it has to be presented as evidence in the record, not just speculation. But that's a good point. Maybe that was, and I'm not sure if the prosecution is going to get a chance to do a reply brief to this. Remember, we still have about 18 days, 18 or 19 days until the actual hearing. So it might be that the prosecution will do a shorter brief in reply to this, and they'll address that. Yeah, yeah. Nine-toe. Yeah, Tyler Robinson's lawyers, they know that their client is screwed. The evidence, just that we saw their client is screwed. There's much more. They know that. They're trying to save his life. That's what a good lawyer would be doing. And they are good lawyers. You guys, I need to get back to work, but thank you so much. Uh, check out the full thing. Maybe I'll post a link on the description. But I gotta. Do I do I think he'll enter a plea immediately after next hearing? Not immediately. Not immediately, because it doesn't hurt the defense to try to get more evidence excluded and other things. So usually the plea is not entered right after. I'm sorry. Usually a deal is not entered right after a plea. Oh, do I think he'll enter a plea? I thought you meant like plea deal. Yeah, he's gonna have to enter a plea of not guilty uh after the court hears argument or the closing argument for the preliminary hearing. Okay, gotta go, everyone. Thank you so much.